Welcome everybody, and welcome everybody coming in on Zoom. I'd like to begin today with an acknowledgement of country, recognising the traditional owners of the land and waters on which Melbourne Law School is situated, and paying my respects to their elders past and present. Today marks a kick-off of the CREEL seminar series. I was not very successful at arm twisting other people to start off the process of seminars, so leading by example was where I ended up today. So it's with great pleasure that we reinvigorate this aspect of CREEL's activities. We've already had several more informal meetings and lunches and just general get-togethers, but it's really nice to be able to have a semi-formal presentation today. I would very much like to make it one where there's plenty of time for questions and discussion. I want to do a little bit of preliminary before I move to the actual seminar talk today, and perhaps a few insights in terms of where this work comes from. It's the culmination of many years of my scholarship, I think, and also some more immediate work that I've been focusing on as part of an ARC discovery project. So I'm just going to drop this screen and move to the next one. And just finding this one with the wrong set of glasses. Thank you. Okay, so the title for today is Property Acquisition and Compensation, Environmental Regulation and Cultural Loss. And it brings together two major themes that I've worked on for many years. Environmental law, its interrelationship with property, but also in respect of Indigenous rights to land and waters. And again, it's another interface there. And the work today is also part, as I said, of an Australian Research Council discovery project on property as habitat. I hold that discovery project with Margaret Davies from Flinders University and Nicole Graham from Sydney Law School. And it's nearing its completion, but as one of the outputs of that project, this was a thinking through about reconceptualizing property through the lens of this idea of habitat. And so I've just got up on the screen for you an extract there from some of the thinking that we did in an earlier article, Situating Property Within Habitat, and that came out in 2021 in the Journal of Law, Property and Society. And in some 50 pages or so, there's some working through in various ways around this idea that habitats actually underpin property rather than often being seen as something that is extraneous to the property right. So our reworking was around, I guess, a reformulation of ideas of essential values and so on, which are encompassed within property law, but also picking up some of the distributive justice implications of property in terms of the way in which property regimes regulate use, distribution, and disposal of resources, and also impact the processes that constitute the habitats in which they are embedded. I've spent the morning looking at Victorian planning schemes around the idea of existing use and its intersection with the native vegetation framework. So these ideas of the coming together of property and the habitats in which they are embedded operates at all different scales in our society. One of the influences in particular, and this is very much Margaret Davies' influence in her work on new materialisms, but I think Nicole and I also have contributed much here, is to think about the very embeddedness of property, that it speaks from a place that it is affected by its materiality, where it's located. Now, those ideas may seem quite simplistic, but I think one of the central tropes that we see in property law is that it has been seen as disembedded, if that's a word, that it is in effect abstracted from its situation. And the very idea of property as a bundle of rights reinforces those central ideas. Just to pick up that last bit, property regimes obviously vary across time, space, and culture, but one of the commonalities that we trace out in this article is that there are common foundational conditions and effects that occur cross-culturally with respect to impacts on habitat. So that was by way of a more general introduction to the discussion. The second part of the ARC discovery project has been concerned with a Rutledge handbook, and that has been a major component of the project. Again, it's about reconceptualizing and rethinking property, but this time we brought in some 37 or 38 other authors to help us in rethinking through some of these ideas. And so it's currently under production with Rutledge and due for release, hopefully middle of the year. But I just wanted to give you a little bit of a taster in the hope that you'll be interested to follow up when the handbook publishes, and we will have a more formal launch. But we, as part of the rethinking of property law and its interrelationship with areas such as habitat and environmental regulation and so on, we used this type of framing that you can see on the screen there. Dispossession, development, and displacement. The idea of habitat as home. So we looked at a lot of the work that's been done around reconfiguration of ideas of homes and housing, display, and for example, squatting and so on. Part 3 is very much the theme that was picked up in that habitat article, but extended by thinking about natural resource management and a number of different regimes that intersect with property, such as mineral resources and so on. The final part is a working through of power, space, and territory through the lens of a reformulated property law. And that's where the chapter in the handbook that I will talk to is situated. So it's picking up what is sometimes called a relational theory of property. This has been a major trend in property law scholarship, perhaps over the last 15 years or so, to think not so much about property as an abstracted construct of a bundle of rights that enable certain powers to be exercised, but to think about the way in which that exercise of power that property confers is actually situated and exercised by people and has impacts on places. So let's turn now to thinking about this idea of compensation. And as we were putting together and framing up the handbook, I'm not a very good arm twister, because Nicole and I asked many people, would they write on compensation? And you can guess what the answer was. Oh, very busy this year and next and in the next decade. So yeah, we found it very difficult, and I'm looking at a person directly here who has written extensively, and we should have thought in my very own law school, but at the time I was perhaps COVID tunnel. So I said, well, we can't have a property law handbook without at least some reference to compensation. So of course, one has to eat one's words, don't you? So hence I ended up with this chapter. But of course, it's very much informed, as I said, by my broader ideas of scholarship about the interface between property, environment, and Indigenous rights. But nonetheless, it was something that really intrigued me as I started to do the research here. And to acknowledge, of course, that the power of the sovereign state to acquire property, processes by which property are acquired and whether compensation is due, really sheds such an incredible light on what we understand property and property law to be in a society. And I think these questions of compensation are really going to reach a flashpoint in coming decades as we think about the growing regulation that is being attempted. I mean, climate change is just one area, but certainly there is a building momentum of regulation, environmental and resource regulation, land use planning, under the auspices of achieving greater sustainability. And clearly there are going to be coming conflicts that are intensified. We obviously have a trajectory already of constitutional case law in these areas, but I guess my prediction in this chapter, based on not only my own research, but other scholarship, that this is going to intensify. And so I think I just need to move this over a little. And so picking up this idea of the conflict between public purpose and private entitlement has been very much a theme around this scholarship. So I've got a quote there from Andrew McIntosh and Amanda Cunliffe that these are not new tensions. This idea of the tension between the public purpose and private entitlement has certainly reverberated for many years in property law. But where I wanted to go was beyond that public-private tension, to think about those entwined issues as not being self-contained, if you like, but really pulling through around historical and legal processes by which communities were and still are displaced from their lands and waters with minimal or no compensation. And if I can just flip back to the very start of the property handbook, normally you start with property rights and the idea that there are strong constitutional protections. We made a deliberate decision to actually start, as you saw in the last, with dispossession, with displacement. And the very opening chapter is a discussion or a contribution by the Gaywu group of Indigenous owners and geographers who live on the lands of the Go land rights case. So we actually situated, thinking about embedding place, with this idea of building on dispossession as an underpinning structure, if you like, on which property rights and indeed later claims for compensation should be thought about. And in this way, what I was seeking to do in this particular chapter was to think about how our case law on compensation, both in the USA and here in Australia, which are the two areas of scholarship that I looked at, are actually predicated on an earlier dispossession. So if you swap your timeframes and you actually use a colonial or post-colonial lens to think about when compensation scholarship starts, what are the timeframes in which it operates, then then we actually take a different lens, I would argue, on this idea of compensation. That typically those claims, for example, of having one's private entitlement infringed by public purpose environmental regulation actually stands on the shoulders, if you like, of an earlier dispossession, which is often not recognized. So that's the underpinning theme, if you like, that runs through this seminar. And the aim was to bring together into that space these relational theories of property, to bring together in one sort of space, if you like, a discussion of laws for environmental protection, property, and compensation for cultural loss, which is just emerging here in Australia under the Native Title Act, together with our more conventional understanding of environmental law and its interface with compensation schemes. Just a couple of things that I think most of you will be familiar with is often compensation is very much not only at the level of a claim for legal rights, but there's a great deal of rhetorical insistence and rhetorical importance attached to compensation. Classic components of the rule of law are held to be, or rather property law and just compensation, of course, are held to be integral to ideas of the rule of law. And we have a long celebrated common law tradition that associates the freedom of the individual from the coercion of the state that is grounded in compensation where property is acquired by the state. I think I've covered that second dot point there around these concerns around environmental devastation, though, are entangled with historic and contemporaneous impacts on Indigenous peoples' connections to land and waters and their property rights. Again, this is the attempt to destabilize, if you like, our conventional understanding of compensation. So we don't see the same sort of, or it's just beginning, I think, to see that type of rhetoric discourse around freedom and rights that we associate historically with property being translated across into the Indigenous realm. Look, these are just a little bit of a working through from this chapter around constitutional protections. And I think we're all pretty well familiar with some of these forms of constitutional protections. Many nations, this is drawn from Greg Alexander's work, who's probably one of the foremost constitutional property scholars in the US. Obviously, the Universal Declaration of Human Rights. We typically have constitutions that subject the acquisition or expropriation of land by governments to very stringent legal requirements and so on. And I've just mentioned previously the rule of law stringency with respect to common law protections for property in that tradition. I think I've probably covered some of those ideas about many current nations with legally entrenched prohibitions on unlawful taking of property. They've actually resulted initially from a colonial acquisition of land and resources by imperial colonizing powers. And what we're actually starting to see again is some unraveling of those ideas. And I've just referenced there on the slide one of the claims by representatives of the Ovaherero and Nama peoples who filed suit against Germany in the US Federal District Court in New York. They were seeking damages due to the confiscation of land and cattle during and after the 1904 genocide in Southwest Africa in Namibia. So you're starting to see these border claims occur. Okay, I want to now move from those more general ideas that frame the discussion around the two pieces of jurisprudence that I want to focus on, or two trends of jurisprudence I want to focus on with respect to compensation and property. As I said, I set up in the chapter a discussion both of the US regulatory takings doctrine and the constitutional case law that we have here that I don't think we could say is anywhere near as structured in the sense that it is, and I'm open very much for a discussion here. I think the Australian constitutional case law in terms of the thread of environmental regulation impacting resource and impacting various private forms of entitlement is different in nature, because in many ways the impacts are entangled in federalism. And I'd be very much interested in Michael's views around the extent to which there is a perceptible difference that I'm arguing for between the USA and Australia, where the environmental regulation has played out, for example, with a Commonwealth state focus that is not seen to the same extent, I would argue, in US regulatory takings. That's a big claim to make, but perhaps we can discuss it. Okay, so in thinking through this iteration between Australian and US jurisprudence, I used some of Jeremy Waldron's work. He fortunately had written on this topic, so it's always good to find this article that works through a lot of the case law for you. Jeremy Waldron, in a very well-known piece in 2012, worked through the differences between what he saw as more or less a UK-based common law tradition, and he made a distinction with the US regulatory takings doctrine, and that in part informs my view that there is certainly a perceptible difference. And it relates to that quote that I've got up there from Waldron's work. He says, "Is it the role of the rule of law, considered as one of our most cherished political ideals, to protect people's property from these sorts of regulative incursions?" He was referring to what happened in Lucas and South Carolina Coastal Council. I'll give a brief introduction to the facts in a moment. So should our rule of law ideal be one that is there to protect, if you like, private entitlement from regulatory incursion, or should we reckon that the rule of law is as invested in the enforcement of environmental legislation as it is in the upholding of traditional property rights? And I use this quote, as I said, to then be the lens to look at various cases in the US and Australian tradition. One of the points that I think is helpful to think about in the Lucas situation, are people familiar with, I know not everyone, okay, so a very quick snapshot. Lucas was effectively a property developer who bought a piece of land way out on what we would call a spit, effectively, of sand. And he wanted to basically place luxury villas on that spit. It was subject to regulation, effectively what here in Australia we would call setback requirements and various other forms of environmental regulation. It was basically shifting sand right out and subject to not only the vagaries of tides and so on, but if you think about sea level rise, increasingly things like climate change. So Lucas was arguing that the imposition of the regulation, the environmental regulation, which was going to preclude building on this quite precarious site, affected a taking, a regulatory taking, in the sense that it sterilized the use, if you like, of the land. It deprived Lucas of the economic benefit. And this was upheld by the Supreme Court in what is often seen as one of the high water, both literally and figuratively, a high water mark of the protection of private property under the regulatory takings doctrine in the US. It builds on, and I would argue, intensifies a focus on deprivation of economic benefit that derives from the Penn Central, which remains the core of regulatory takings doctrine in the US. If you've been to New York, you've probably gone through Penn Central Station. Yes? Okay. So this is one of the seminal case in US takings law. Effectively, Penn Central Company wanted to renovate its Grand Central Terminal. If you've been there now, you'll see it's beautiful. It's got that wonderful ceiling and so on, but it was in quite a state of disrepair at the time in 1978, and there was an application basically to demolish and or actually to renovate this building. And this application was rejected by the City Commission because it was subject to the landmarks preservation law, very similar to our cultural heritage protections here in Australia. The Supreme Court, in rejecting the argument that the New York City regulation constituted a taking, it set this basic test that has been replicated through various forms and extensions in later US takings doctrine. But effectively, it sets this two-stage inquiry. And I can go into that, but it sets, if you like, a balance. Oh, sorry, I've just hit that. In the sense that what must be determined is that there are three factors. So what's going to be the economic impact of the regulation on the owner, the degree of interference with an owner's reasonable investment-backed expectations, and the character of the government action. So those are the factors that are considered, and it's a balance between those factors. So that's the Penn Central test. Now, I'm not going to do the detail of further takings doctrine. I do step through that, and this is very well known. I claim no great scholarship here. I would like to acknowledge a debt to Professor Erin Ryan of Florida State Law School, who was very gracious in stepping me through some of the later case law. And so if you are looking for an overview of both the regulatory takings doctrine and also how it interfaces with the public trust doctrine in the US, I could thoroughly recommend Erin's work to you. I just want to leave that point there, because, or to make, sorry, one final point, which is what I argue is that you have an intensification of protections for private entitlement that, as I said, reach, I think, the high point in the Lucas case, but the idea of indirect regulation, which is core to the idea of a regulatory takings, remains, I think, much more entrenched in the US constitutional doctrines than in Australia. And I just want to now turn very briefly to consider Australian case law in that context. And I think just this discussion of the nature of property picks up what I would argue is that difference in the treatment of property in the US. And obviously you've got a constitutional entrenchment there that's assisting. But you know, that's a very recent Australian High Court pronouncement there. So property is not a monolithic notion of standard content and invariable intensity. Accordingly, to characterize something as a proprietary right is not to say how far or against what sort of invasions the right shall be protected, because the protection given to property rights varies with the nature of the right. And so I think the absoluteness of property, if I can use that term, that we see in the US is qualified in particular ways here in Australia. Now, obviously, there are various interpretations that we've actually seen around property rights and compensation by the Australian High Court. But certainly, I think there's what I would argue there is a sort of a fundamental shift away from absolute values for property there. And one of the things that I want to contrast to that more qualified sense of property rights and compensation requirements for any taking of property here in Australia is that we are also seeing, I would argue, and here I'm drawing very much on Pam O'Connor's work and scholarship. Pam is a wonderful property lawyer, and she has done quite a lot of work on the influence of US regulatory takings doctrine and the strong entrenchment of private property rights that she contends accompanies that development of doctrine in the US moving into Australia. And she identifies in particular Justice Hayden's dissent in the ICM case in 2013 as exemplifying that trend. Now, I want to pick up a later case or a slightly later case, contemporaneous almost with the ICM case, and that is the Spencer case. Because ICM, I won't rehearse all the facts here, but in the ICM case, the facts were that there was a challenge by groundwater license holders to the replacement of earlier water regulation by what are now known as NWI, National Water Initiative style licenses, which were, instead of being a set volume of water, became a share of a resource, a proportionate share of a resource. The holders of the groundwater licenses that made the claim for compensation were given an ex gratia payment, but they argued that it wasn't sufficient to meet the value. Now, in that instance, it wasn't the Commonwealth directly compensating. There was a quite involved federal arrangement whereby the Commonwealth government made payments available to the New South Wales government as an incentive, if you like, to adopt this newer style of environmental regulation in the water space. So the just terms clause in the Australian Constitution was arguably not directly invoked, but indirectly invoked. And that's important in the Spencer case. The Spencer case is, I think, very interesting if you're looking at what as I said, I think will be an increasing trajectory of litigation around environmental regulation and property rights. This case is already listed in a lot of the climate change litigation. I think it's much more broadly based than that, but nonetheless, that's where you'll find it on a lot of the databases. The Spencer case, Peter Spencer argued that there was an indirect regulation of his property in rural New South Wales by legislation that prevented him from clearing. He argued that the benefit of having the carbon sequestration of the trees staying in the ground, there was no compensation for that benefit, and in effect, it constituted an acquisition by the Commonwealth of the value of the carbon sequestration that because he was prevented from clearing his property and making it available for other uses. In a series of federal court cases, effectively, Mr. Spencer was unsuccessful, but it did go on appeal to the High Court. And while they didn't substantively decide the matter, it was held that it was arguable that there could have been circumstances in which there could have been acquisition of a benefit. And so the case was remitted back to the full federal court, but same result, no finding of an acquisition. And I think this is really important because, again, relying on some of Pam O'Connor's work, she argues that this is very much taking an argument that we see in US regulatory takings doctrine, and it very much informed not only the manner in which the action was brought, but there was a strong support for Spencer by a property rights group here in Australia. So I just want to leave that there because I want to leave us some time for discussion. So let's put those pieces of constitutional jurisprudence from the US and Australia aside for a moment. And I want to bookend as a final thought to bring us back. And I wanted to turn us to the Native Title Act. Australia doesn't have constitutional protection for its Aboriginal and Torres Strait Islander peoples. It's anomalous among many settler nations, and indeed many nations. I'm looking at my Peruvian friends here. So in its place, we have the Native Title Act, and it codifies the processes of sovereign extinguishment or impairment of native title rights and interests and the claims for compensation in certain circumstances. And what I finish off in the chapter is thinking about the Northern Territory and Griffiths case, the first time that the Australian High Court considers a claim for cultural loss, and that's decided under Section 51 of the Native Title Act. What I want to highlight as a final thought is that the framework for deciding cultural loss is one that is referenced against settler property law. So your value of your culture becomes, if you like, understood within the framework of property law and obviously the jurisprudence on compensation that is associated. And I guess my argument then is to come back full circle and to think about the way in which property law and compensation, as we conventionally understand it, is actually predicated on an earlier colonial dispossession. And this point, I think, is not lost on the full federal court. And this is a quote there. So the incongruity of using land law as the yardstick of value. So native title rights and interests are of such a different type and significance to the holders that it may well be appropriate to loose the assessment from the shackles of Australian land law and approach the compensation exercise without dividing value into economic and non-economic components. So I'll leave it there. Thank you very much. I've thrown a lot at people in a short space, so I'll open it up for questions now. Thank you. Yes, a great question. Look, it's a very interesting thing that our planning system here in Victoria, and well, with some exceptions, there is not a general, how could I put it, not a general expectation that compensation will be available with respect to various forms of environmental regulation. And yes, I think it is quite likely that the way in which the acquisition of a benefit is construed under the Land Acquisition and Compensation Act is likely to be much more tightly defined than you see, for example, in the Lucas case. And that's certainly what I would be arguing, that is a difference here. And for example, Queensland does have some compensation provisions in its planning legislation, but yeah, quite different, I think. And certainly in relation to the general land acquisition and compensation regimes, it's much more where there's what I would call a direct acquisition of the value or direct acquisition of the land, which is very much like the earlier model of US regulatory takings doctrine, I would argue. It's a great question, yep. Yes, I agree, Eugene. And indeed, I think the comparison has been made. I think there's a couple of articles that deal with the Spencer case in that context, in relation to compensation. Did you want to sort of draw out another point, or just expand there? Because I'm not exactly sure what aspects you wanted me to comment on with respect to the plain packaging case.
I just thought it was an interesting contrast, or the interestingly different approach, that's all. I'm not that familiar with the Spencer case, but I have written on JT International. So I was just wondering how similar, how different they might be in terms of the approach.
Certainly, well, in the JT, and you can tell me because you're the expert there, but the idea of health regulation being imposed for a public purpose, and obviously then affecting economic value, or arguably an acquisition of a benefit idea. I think, as I said, that's much more tightly constrained, I would argue, here in Australia, and certainly the way in which the full federal court dealt with Spencer's case when it was remitted back down from the High Court, didn't give much scope to a more general, if you like, indirect acquisition, indirect regulation causing an acquisition of a benefit through, if you like, loss of economic productivity effectively. So I think there are certainly parallels in the way the approach was framed. I think the outcome has been, well, in some ways, I suggest in the Australian context, the outcomes are possibly congruent in terms of the priority given to a public purpose.
I would say, Lee, especially that the argument in JT International, to me, seemed to be weak, especially where it concerned acquisition of intellectual property rights, because really, the cigarette companies were still free to use their brands, their trademarks, and their names in other areas. For instance, on their websites, on their buildings, or on their letterheads, but it was just in a very discrete area that they were not allowed. So I thought that was a bit of a weak argument.
Oh, I can see, yes, where you're arguing that it was weak in that sense. I think when you're looking at a use of land and the acquisition or an indirect, if you like, acquisition of a benefit, as in Spencer's case, because you're impacting the, if you like, the economic viability of the use, I think there is a point of difference. Difference there. Yep, great. Rebecca, thanks. Rebecca?
Thanks, Lee. Yeah, I wanted to raise with you a slight twist on the scenario of compensation for the effects of environmental regulation, to just raise the scenario of conservation covenants, where the government encourages and rewards people to use their property for the benefit of the environment, but simultaneously allows others, notably resources developers, to come in and not acquire in the same way, but to take away those investments. And my reading of the law is that there is no compensation for those kinds of investments. It's not in the nature of built infrastructure or sort of traditional ideas about the benefits of property. And I'm just wondering whether you had come across this issue in any of the case law or any of the frameworks that you'd looked at, either in theory or in practice.
No, I haven't. Although what I would say is that the movement that gave rise to the Spencer case, I see it coming through now in, for example, the steward, I don't know if you're familiar with that stewardship bill that's just been, I think it was the last session of Parliament. So that this is an idea of biodiversity and carbon credits for landholders. So whether in fact then, if, for example, gas or companies come in, I'm looking at the expert in this area, Michael, your views. Obviously there would be compensation payable in terms of buildings, but in terms of something like, say, carbon sequestration rights in the trees, do you think they would be, I guess, Beck, is that what you're saying? Would compensation be available where resource companies come in, say, to develop a mine or gas project?
So sort of that context, but perhaps even a little bit more nebulous in that, some of the conservation covenants bind the landowners to undertake ecological restoration, for example. So it's not even that the right is something that's quite as quantified as something like a carbon credit, but just the fact that they've invested in ecological restoration.
Yeah, oh, I see. Any thoughts, Michael?
Well, it opens up a lot, Beck. But let me just make a couple of points. I think it's important to distinguish between governments in our system, because the Commonwealth Parliament, in terms of its legislative power, is limited by the court's interpretation of paragraph 31 of section 51 of the Constitution, which has been read to as amounting to a requirement that that just terms be provided for in respect of any acquisition of property from a person or estate. Now, I'll come back to those terms, but just as a preliminary point, the states are not subject to any such requirement, whether it be in the form of paragraph 5131 or in any other form. The states constitutionally are free to expropriate private property without any compensation together. And this is part of our inheritance of English law going back. And I think this is something that differentiates our position from that of the US. So you've got to be careful about incorporating US authority because some of the constitutional foundations are different. The second point to make, if you go back to the actual language of the constitutional protection that is given in relation to Commonwealth legislation, it's against acquisitions, not takings, which is the situation in the US. And the requirement is just terms, not compensation. And the High Court has made clear, although it hasn't spelled that out in detail, that just terms are not to be equated with compensation. Just terms as an expression is something broader than compensation. Exactly what will be encompassed within it is yet to be determined, although the Timber Creek case does give some indications. So the term acquisition has been interpreted very narrowly. And if you want authority for that, that's the WMC Resources against the Commonwealth case that is quite well established, although some of us think wrongly decided. Nevertheless, it's authority of the High Court of fairly long standing now. And so the fact that a property owner loses the economic benefit of an asset as a result of Commonwealth legislation doesn't necessarily mean there's been any acquisition. And that's what the WMC Resources case says. And so the court here has freed up much more scope for government regulatory action here by its very narrow approach to what constitutes an acquisition of property. It takes a broad view of what constitutes property, but it takes a narrow view of what constitutes an acquisition of property. So, first of all, I am very wary indeed of Justice Hayden's dissent in the Spencer case. I think it's very interesting, but unpersuasive. Secondly, I think it's very important to understand the differences between our constitutional framework and the US constitutional framework. And thirdly, I think we've got to always remember the difference between the restriction on the Commonwealth Parliament and the lack of restriction on state parliament. Durham Resources, there's lots of authority in relation to expropriation of property where the High Court has confirmed that states are not obliged to provide compensation.
Thank you, Michael. And of course, I think that picks up that point with Chris there around Chris Navarro, the Victorian government be able to curtail outcomes. Yeah. Well, it has that, there's a different constitutional platform to begin with, but also I think in terms of the way in which benefits defined there. But there is, if you like, a creeping movement for some of the regulatory takings doctrine, I mean, to come in. I mean, Pam O'Connor was arguing that Spencer's case was using very similar arguments. Anyway, we can debate whether that's the case. Any further comments? Otherwise, I think we're 1 minute over.
Lee, perhaps Michael could shed some further light on JT International. He was the one who taught me constitutional law. Although
Right.
not JT International.
Yes.
Look, I think it's a good example of the consequences of the narrow view of that the High Court's given to the term acquisition in our system. I think whatever effect the legislation had on the proprietary rights of the tobacco companies, none of those effects amounted to an acquisition.
And I think that's really in ICM too, where ultimately.
Well, in the majority.
In the majority,
of
yes.
ICM, that again. Now, you know, I'm not necessarily debating the merits. I'm saying that's the state of the authority. And if you compare the WMC Resources case with a case that involved onshore mining in the Northern Territory, Kakadu State 3 extension from Kakadu National Park, you'll see that habitat location really matters.
Yes, it did.
Whether you're offshore petroleum as distinct from onshore hard rock mining in what became a national park, will affect the outcome.
Yeah, absolutely. When you have your declaration of your park only a certain way down in the subsoil, it's a very interesting manoeuvre. I wonder, well, yes, there was obviously some inventive thinking around your declaration of the national park there. We're referring to a case in Kakadu, what became World Heritage Area, but big conflict, and I do track it through very briefly in the chapter, where there was a zone for mining, but there was debates as to whether it should be a conservation zone. So how do you have a mine in a conservation zone? Very difficult problem to get around, but the way it was done was with this very convoluted declaration of the national park that basically didn't, it was there. The mining rights were affected. I think they were affected. To get to them, you would have had to have gone through the national park at a practical level. Yeah. So
well, you couldn't conduct a mine. It was an open cut mine. Yeah, so you couldn't conduct the operation without infringing the prohibition upon mining in national parks, which this area wasn't originally when the mine was established, but fell within the extended boundaries of the park when stage 3 was declared.
Okay, all right. Well, look, I think that's time. So unless there's any more questions or comments, just thank everybody for attending, and hope it stimulated some thoughts, particularly in terms of different jurisdictions. And you know, that much stronger constitutional protections that exist. I know South American countries have a stronger tradition of constitutional protections than we do here in Australia. Okay, all right. Well, I'll just close off the Zoom then. Thanks everyone on Zoom. Thank you. Thanks.